So, dear friends, we had a wonderful panel on antitrust or abuse control. I mean, the problem is still in place because the ones who have been to this conference 5 years ago in 2019, they might remember the intervention by Daniel Ek, the CEO and co-founder of Spotify, who filed his complaint to the European Commission with regard to Apple. And it seems we can expect maybe a decision on that next week, 2024, 5 years. So the problem is still in place. But now we turn to merger control in order to make sure that it doesn't even come to an abuse proceeding. Maybe we need to be bolder and stricter, or what else do we have to do? We have a great panel here that will be chaired by my friend Nuno Rodrigues from the Portuguese Competition Authority. Nuno, you have the floor. Please give us the way.
Thank you, Andreas, and thank you for the invitation and for the brilliant organization that you made here in Berlin and for your team. I think you were able to blend the best of Christinas Casfaras conference with the best of an ICN or meeting. So this is really a brilliant organization, and thank you once again. So in this session, we'll be talking about merger control, and in particular, merger control in digital markets. So I have here a brilliant set of speakers. They are quite funny in terms of our talk that we have about merger control, so let's see what will happen. And let me just make a small presentation of what we are supposed to talk. So when it comes to merger control, in particular in digital markets, we have seen significant challenges in the current years. It feels like it was many years ago that the famous merger between Facebook and WhatsApp happened, and it seems to be in a different area. So in the meantime, concentration in digital markets is rising in a global scale, and concerns around the killer acquisition strategies of major tech platforms are part of the mainstream debate in antitrust. In some jurisdictions, legislatures are now considering whether notification thresholds should be changed in order to capture deals which do not meet the turnover thresholds. In the European Union, the Commission adapted its approach to Article 22 of the merger regulation, as you are all aware, to give the national competition authorities a more proactive role in capturing those transactions. Also, the DMA includes the famous Article 14, which give some provisions that goes in the same direction. And in addition, there are also issues around whether the existing series of harm allow an effective assessment in mergers in digital markets. So these are some of the few aspects we aim to cover in our discussion. Reminds me of the former panel where we spoke about the more and less economic approach in Article 102. Maybe we could speak here when it comes to merger control in a more dynamic approach that we are facing in the current days. So is there really a more dynamic approach in digital markets and in merger control? So in the first part of the session, we'll have a close look at the main challenges that merger control is facing in digital markets. And in the second part, we'll speak about what is changing in merger control in order to address these challenges and what could still be changed in order to adapt merger control. So I have here a set of speakers that don't need any introduction, but maybe starting with Sir Marcus Smith. He's the president of the UK Competition Appeal Tribunal since 2021. He's a very well-known judiciary, and I will start with him. So Marcus, there is a generalized concern that merger regimes are not working. Based on your experience, what can you tell us about this concern? And how do you see the erosion of the traditional market share approach in the context of digital markets?
Well, Nuno, thank you for that introduction. And can I say what a privilege it is to be invited here to speak. Thank you for the invitation. So merger control's great virtue, and simultaneously its biggest issue or problem, is the fact that it is an ex-ante regime. The virtue, market power, and its potential abuse is avoided before it can occur, as Andreas just said, and competition is furthered without ex-post intervention. That, of course, is subject to having an appeals process or a review process that doesn't render the ex-ante ex-post. And my tribunal's standing policy in mergers is to move extremely quickly. To take an example, the Microsoft Activision merger, which in the end didn't proceed to a substantive hearing but settled, we had the decision at the end of May. We had our first case management conference within 3 days, and that is including the weekend, and we would have dealt with the case substantively by the end of August. So that would have been an end-to-end review process of about 2 months. The problem with an ex-ante merger regime is, how do we know that we are prohibiting the right mergers, by which I mean, of course, the wrong mergers, those that are harmful to competition? Now, we know when we've wrongly green-lit a merger that should not have been allowed to proceed, because, of course, the adverse consequences will be there for all to see when they eventuate. And anecdotally, there seem to be quite a lot of these. Now, that may mean that we are actually red-lighting, prohibiting or restricting mergers that ought to pass without issue. Now, of course, the adverse consequences of this, the thwarting of a beneficial merger, will not be apparent. There will not be a counterfactual in which the merger goes ahead or goes ahead unrestrained. So there is a problem from the very start in validating the outcomes of the merger regime when it engages. And this has always been a problem, even in simpler times. Let's dial back the clock to traditional industries, by which I mean, in broad brush terms, industries operating in markets where there is a degree of physicality or tangibility in the products sold, and I use products to embrace both goods and services. The distinction that I'm drawing, and it is very broad and not an entirely accurate generalization, is between traditional industry and digital or tech industry. And I'm suggesting that the dynamics of these industries or markets are very different. In contrast to the traditional industry, the digital or tech industry moves with lightning speed, with disruptors challenging incumbents rapidly, so that they become incumbents themselves and dominant. And our traditional tools, which focus on market share, are perhaps no longer apt. Now, a great deal of this talk is drawn from the Competition Appeal Tribunal's decision in Meta against the Competition and Markets Authority, where the CMA disallowed a merger between 2 US companies, one enormous, Facebook or Meta, and the other tiny, Giphy. Giphy specialized in planning to advertise and monetize GIFs. I had to ask my daughter what a GIF was, and she also told me, Dad, it's so passé, why are they bothering? There we are. I knew nothing. Anyway, GIFs were clearly big business, and the CMA had determined that a potential rival to Facebook could arise out of Giphy in 3 to 5 years from the proposed merger. But apart from that potentiality, the merger actually had nothing to do with the UK, and Meta certainly contended that the CMA should leave well alone. Basically, the line was, it's none of your business, but out. We rejected that contention, and although we did so, the case serves as a reminder that tech mergers are transnational, and that any given merger is likely to involve multiple authorities who, but in accordance with their national law duties, will have to, or at least ought to, cooperate. Otherwise, we get a case of the lowest common denominator, or veto, which cannot be good in transnational mergers. Now, that's all I'm going to say about the international problem, but I hope others will have more to say. Let me return to the challenges posed by the tech or digital industry. These challenges really turn on the fact that we have lost our comfort blanket. We've lost the ability to focus on assessing these mergers by reference to market share. Meta described 3 forms of analysis for merging companies: static, potential, and dynamic. Static and potential competition assessments really look to market share or short-run growth in market share. Basically, if the merged entities result in a single undertaking that is too large, then the merger is stopped. Now, that is an easy and rational basis for reviewing proposed mergers. And I must apologise, I'm applying an extraordinarily broad brush to what is obviously a much more nuanced and complex process, but I've got 7 minutes and that's it. Of course, market share focuses may not operate as we might wish, but it is at least comprehensible and rationally justifiable. The problem with the tech industries is we lose that comfort blanket and the rationality that this imposes on the process. And that loss is, I think, going to be sorely felt. I have in the past described the process of dealing with mergers in the digital world as crystal ball gazing. Now, that comment has met with a degree of disapprobation in certain circles, as implying that our competition authorities will be acting irrationally or without basis. Now, I hope that those who know me and those who know the cat will understand that that was not my meaning. The problem arises out of the CMA's approval of, the cat's approval of, and close articulation of the CMA's own approach in Meta. What happened there was we approved the use of dynamic competition, or the threat to dynamic competition, as a control over mergers, and that is now UK law, and we've got to live with it. My point is that it is the cat's own decision in Meta, which I continue to think to be absolutely right, has created a problem, and the problem is one of what is going to happen in the future regarding a merger or proposed merger between Behemoth, a very large techno giant, and something which is very small, but which it is said has the potentiality to expand and become a market changer and competitor to the Behemoth, and so that the merger should not be allowed. Now, let me give you an example of the sort of problem or problems that this gives rise to. It's probably an apocryphal example, but it's none the worse for that. Some of you will know that long, long ago, back in the mists of time, the personal computer market was dominated, particularly in the States, by a company called Commodore. A basic language personal computer, somewhat more sophisticated than Sir Clive Sinclair's ZX81, with active RAM of 1K, but with basically 1,000th of the capacity of a cheap mobile phone today. But in the market then, dominant. And into the California office of the Commodore's CEO, in walks a sandal-wearing, short-beclad, bearded student, offering to sell the CEO his company for $150,000. And the CEO said no. Commodore went bust a few years later, I'm sure for reasons unrelated to this transaction. But the student's company became a behemoth in its own right. The student's name, Steve Jobs. He hadn't got round to Polonex at that stage. The company, Apple. The problem is that the CEO's response, the no, I don't want to buy your company, was completely defensible. No was a very rational answer. But suppose the CEO had said yes. It is difficult to see how the merger or takeover that Jobs was proposing could sensibly be disapproved without enormous speculation by any competition authority. Of course, you can make the argument. Jobs looks like, even though he's wearing sandals, an amazingly talented individual. The Apple II he's planning knocks the spots off the Commodore machines, if it ever gets built. Apple will become a great innovator and will go on to make the iPad. Now, that last point is pure crystal ball, and probably you'd say something like, and will go on to invent other great products beyond the Apple II. My point is, all of this is highly speculative, and so very difficult to reach a firm conclusion as to whether the merger is good or bad. Why, one must ask, is this particular future, instead of the myriad of other possible futures where Apple fails, the future that the competition authority selects? Why does one, on the basis of that one possibility, say that the merger should be disapproved? How do you say, as the merger authority, that one vision is better than the other, particularly when you are prohibiting something which is otherwise lawful? And look at the problem from a reviewing court's point of view, as I do. Basically, the choice is that if such a decision is served up prohibiting the merger, it is either for the court to say, well, this reasoning is so speculative that it is one possibility out of many futures, and just that speculation, no matter how well put, the decision cannot stand, or one says, this is the considered view of future development of the authority, It is not as a prediction impossible, it is one of the vast range of possible futures, and so not unreasonable. The decision must stand. My point, and I will finish on this, is that neither of these alternatives is particularly attractive. The former approves too many mergers or merger decisions, and the latter effectively closes out review. We have, it would therefore appear, a binary choice between a blank check to the reviewing authority versus an inevitable overrule of the authority's decision, and neither course is acceptable. So we have, I think, a real problem arising out of the nature of digital industries, tech industries, as I've described it. I'm going to stop there. I hope we have a later round of discussion at which I can moot some potential tests to resolve this problem, but be warned, I don't think I've got the answer. Thank you very much.
Thank you, Marcus, for your clear and panoramic introduction to the problems we are facing in merger control and from a judiciary perspective. Now moving to Tommaso Duso. Tommaso is an economist. He's head of the Firms and Market Department at the German Institute for Economic Research. And since 2022, Tommaso is a member of the German Monopolies Commission. So Tommaso, moving to you, what's your view on the current challenges in merger control in digital markets? We are aware of the DMA, new series of harm. So does enforcement need to be more rigorous or not, and why? So.
Yeah, thank you, Nuno. Thank you, Andreas. To have me on this panel today is a great pleasure. Being in the almost last panel makes almost impossible to have many new things to say, because many of the things I plan to say today were things we touched upon over the last 1.5 days. So, but I think that sometimes it's good to repeat things and to make some position clear. And the position that I have is that merger control, especially in digital markets, but not only in digital markets, has been under-enforced in general, especially in Europe, even more in the US, in the past 10, 15 years. In digital markets, this is very visible. There was simply no action until a few years ago. All mergers were approved. There were no prohibition. There were hardly any remedies. And this might be problematic. So now it seems a different age, but in 2019, together with Lea, we wrote a report for the CMA evaluating mergers and merger policy in digital markets. And there were many pieces of evidence that we tried to put together, and we did some ex-post evaluation of some cases, among which Facebook, Instagram, Google Waze, Priceline Kayak, Amazon, the book depository, and we realized in this ex-post evaluation that first there have been some issues in the process, in the choice of the theories of harm, understanding competition in these markets, and also exposed the outcomes, although that is much more difficult to measure, but in our view, these mergers have been problematic for competition. So there was under-enforcement, and this under-enforcement has been problematic for the evolution of these markets. Now, things are changing, and we heard it yesterday. All the mergers decisions that happened in the last, 6 months, 1 year? The first blocking of the European Commission, booking e-Travely, 2 other mergers that have been withdrawn, quasi-prohibition, Amazon iRobot and Adobe Figma. We heard from Fiona yesterday in the US, Illumina Grail. She mentioned a big success. So things are changing, and things are changing because I think competition authorities learn, not only competition authorities, also academics. We learn to understand better what is the world, the future that we should see in this crystal ball. So maybe it's easier now to address these issues. But so again, a step back, why I think that merger enforcement that was not working very well in digital markets is so fundamental. And again, so it's nothing new. We discussed it yesterday as well. We discussed it 1 hour ago when we talk about abuse of dominance. There are some specific issues in digital markets that make merger enforcement even more important than in traditional markets. Although even in traditional market, merger enforcement is important because it's ex ante. Digital markets have this natural tendency to monopoly, network effect, economies of scale and scope in data, innovation dynamics, winner take it all kind of competition, right? So if on top of that firms are allowed to grow by buying potential competitors, that makes the problem even larger. And the cost of these type 2 errors is enormous. We learned that abuse of dominance is difficult, right? So I was very positively impressed by the French competition authority. So that gives me some hope that abuse of dominance can be a tool that helps solve competition issues in market that tipped. And but still, and the records are not particularly good. Monopolization, when it happens, is really difficult to revert in these markets. Entry barriers are large. Yesterday we heard how difficult for small firm is to get access to essential inputs like data that are fundamental for their business case, for making money, for their margins. Innovation is also difficult. We had this discussion about killer zone. It's difficult for a startup to get finance for an idea that is in the shadow of big tech. So monopolization is very difficult to reverse. Abuses are particularly likely, and I read of a very interesting new study by Christian Bergqvist, who has identified over 100 abuse cases against Google. So we were talking about the small numbers across the globe. 100 cases only for Google, right? So this is like a repeated offender, right? So remedies, and we learn it, do not work very well. Very often they have behavioral remedies. It's difficult to monitor. They are complex. Structural remedies are not used very much. Breakups, I mean, we are still waiting for it. Things are happening. So instruments are coming. So that might be a possibility. I think you, Andreas, said so. You better are compliant with the DMA, because else we have to break up, right? So now that is a threat. Politically, it's still very difficult. I don't remember who said it in the panel before. So to break up, for the French authority, for a German authority to break up Google or Facebook is politically a challenge, right? So, and of course it's easier, it's still difficult to break up a public monopolist. So as member of the Monopoly Commission, we have some issue with the Deutsche Bahn. I mean, we are not saying breaking up, but the vertical separation is maybe something that could help. Right, so, and even there it's difficult, so think about this big tech. Abuse cases are very slow, and I don't need to say more than that because we talked 1.5 hours about that. And on top of that, there is this particular issue of digital platforms that goes beyond just competition. They are so crucial in modern society. We learned it again yesterday in the discussion about AI. We know the Facebook analytical case, the fundamental role that these platforms play in democratic life, right? So it's a big issue. So having concentration of economic power in these markets is even more dangerous. So in that sense, I think that merger control needs to be more toughly enforced, especially in digital markets, but in general. I like the message of Margarete Vestager in the last month of her second mandate. The new commission should be bolder. I hope that the commission will be bolder. I think they are moving in that direction. I think national competition authority should be also bolder. And I'm generally a very optimistic person. After the AI session yesterday, it was a dark future in front of us. I think there is some hope. I think, and we will discuss, we have beefed up the portfolio of tools that we can use. I still think, maybe because I am obsessed with merger control, having been researching the topic for the last 20 years, that merger control is one of the key tools because it's ex ante. So just try to carefully see how this market develops before they tip, and then it's difficult to intervene ex post. And I'll stop it here.
Thank you, Tommaso, for your presentation. You talked about the challenges that merger control faces, also to public enforcers. Let's see how to address those challenges in the second round. So now moving to Nelson Yang. Nelson Yang is a partner at Clifford Chance. He's a private practitioner, but he has also experience being a public enforcer. He was a director of the merger group at CMA. So I think you have both of two worlds, and you can give us a very interesting insight of what you think the problems we are facing, namely what you think about the recent rise of conglomerates and the so-called ecosystem series of harm that we've seen just recently in the decision Booking It Travelly, and also considering other digital merger deals such as Adobe Figma, MSFT Activision, and Amazon iRobot, which didn't happen at the end because it was the draw. So in your opinion, was Booking It Travelly a one-off, or is it a trend which is here to stay? What's your opinion and thoughts of that, Nelson?
First of all, thank you, Nuno, and of course, thank you, Andreas, for inviting me to this truly wonderful conference. I mean, 1.5 days of excellent discussions, not to forget the great evenings, so thank you very much for that. Just listening to Tommaso just now, and I have to say, a lot of what he said does resonate with me, but it is kind of difficult not to take it personal, Tommaso, in some ways, because when you mention the sort of era of under-enforcement, that clearly falls right into sort of my time when I had the honor of being head of mergers in the UK. And you also mentioned a few cases which I probably have some regrets about. But just picking up on sort of key themes of this conference so far, and I think one key theme was, of course, the alleged cartel between Christine and Andreas, which everyone is sort of seeking to get their head around. But the other one, I think, that came out of yesterday's discussions was, you know, we really need to focus on what matters, right? And this is, of course, also relevant to merger control, because we now sort of have a period of time where, you know, the much talked about antitrust pendulum has swung the other way. And there's now still a need, I think, for legal certainty and for clarity around what the enforcement priorities are and which mergers should and shouldn't be going ahead. Just maybe briefly, you mentioned Google Ways. Just sort of taking a step back, that was one deal that we looked at in the UK. I don't think anyone else actually in Europe looked at it at the time. You have to imagine that this was about a decade ago. Mm-hmm. And I think this was revisiting of Article 22 of the EUMR, so there wasn't that invitation for member states to refer to the European Commission cases where their respective national jurisdictional thresholds weren't met. So it was just the UK looking at it because we had different jurisdictional thresholds, very flexible ones, as most in the room probably know. And at the time, I think we didn't focus on what really mattered. I remember going into the meetings, having been told that actually Google and Waze were fundamentally different in terms of what they were offering. This is the sort of turn-by-turn satellite navigation apps, which you may know. I won't go into detail. We did sort of ask ourselves the questions, how disruptive was Waze to Google? So there was sort of, you've studied these decisions well. We sort of thought through, but ultimately, I think drew the wrong conclusions, I have to now say in hindsight. If you drive around at least London in a cab or an Uber, I think you'll be hard-pushed to see anyone using anything other than Google Maps or Waze nowadays. And so it does sort of beg the question whether we missed a trick in terms of a slightly differentiated business model that could have provided more of a competitive constraint on Google had it maybe been acquired by someone else or sought that funding elsewhere. So yes, mistakes were made. The pendulum has swung the other way, but I don't think that this, and you're not suggesting that, but that this would obviate the need for really an in-depth assessment of each and every case and the evidence that's lying before you. And I sort of like the notion of a more dynamic approach rather than sort of a less economics-based approach, because I think economics must play a key role in seeking to predict outcomes. That's what we're doing when we're sort of trying to crystal ball gaze. We're trying to understand what will happen. And sometimes using data and economics are really helpful. And maybe just to get this off my chest, there is, of course, we heard a lot about Brandeis and the paper he wrote, I think, 90 years or so ago, Curse of Bigness. When people nowadays talk about antitrust enforcement, you hear a lot that, antitrust really should support democratic principles. And I totally agree with that. How could you not? But what sometimes I think in these discussions can happen is that people either forget about or maybe risk belittling the need for legal certainty and, ultimately the rule of law. So understanding what your legal basis is to intervene, there's still an intervention in someone's freedom and economic activity in this case. It's kind of a big thing. So we need to think quite carefully when the state or government should and shouldn't be intervening and how clear it is, because that too is a key element of a functioning democratic society. So I just want to make sure that, as the pendulum swings and swings and swings, that we still keep some sort of basic principles in mind and don't forget about these important points. In German, one of my favorite German words, and I am German, is Ermächtigungsgrundlage, and it sort of captures what I mean. Sort of really being empowered to have a legal basis to intervene. So it's an important concept which we should bear in mind. Okay, I'll get to the point. So what does that mean in practice? We now see these cases, you mentioned Booking e-Travelly, where we obviously still haven't seen the decision published, unless it was published last night. I haven't checked. Where you have the Commission openly saying, well, you know what, we departed from the guidance. We looked at this sort of theory of harm, which I sort of think of as sort of kind of reverse leveraging, sort of strengthening the position in your core market by virtue of acquiring a target business that's in an adjacent market, strengthening thereby a dominant position. And so Gersin and others say, well, you know what, we didn't follow the guidance here. We didn't use the sort of ability, incentive, effect framework that we ordinarily do for non-horizontal mergers. But we thought we were right in doing so because we thought there was harm arising from this. And I have to say, I sort of, not to commenting on this case, but I understand that there will be instances where there's a need to do so because otherwise things probably wouldn't develop. So I sort of see that that's important. But what we then also need, I think, is importantly some limiting principles around that evolution, so that we don't live in a world where we as advisors are confronted with questions, well, I'm kind of big in this market, can I buy anyone? Or, what are we actually saying? At which point in time would we expect intervention to occur? And people, you mentioned all the big cases, both of you, Meta, Giphy, Adobe, Figma, Amazon, iRobot, now Booking e-Travelly, you name it. Listening to Tommaso's introductory speech, Valetti, earlier, and sort of this reference to the need for new presumptions or reversal of burden of proof and merger control, I have to say I don't see it. I mean, I think the agencies have demonstrated that based on the very same law and legal framework, intervention can happen, and in fact, it does happen. So I don't really see that as a big gap. I don't really see the need to introduce new legislation, but I see the need for limiting principles. And when people think through what these new cases mean, sometimes what is forgotten in the debate are the clearance decisions. I remember we had to put a lot of effort at the OFT and CMA into our clearance decisions because they too can be challenged and have been successfully challenged, unfortunately. And so there's a lot of wisdom, I think, one can derive from them. And I want to, in this context, just mention two decisions. One, again, full disclosure, Amazon MGM I was involved in, and then also Google Photomath. Because in both cases, I think you might be able to see some parallels with the underlying theory of harm as we understand it in Booking e-Travelly. But of course, those cases were cleared. So why were those cases cleared? I probably won't have time to go much into the cases, but of course in Amazon, the core market was defined by the Commission essentially as the provision of marketplace services, and MGM provided audiovisual services, and through Prime, the Commission said this is somehow connected in a conglomerate way. So, we need to assess to what extent the marketplace service provision is strengthened, and in Google Photomath, this is different altogether. This is homework and study help tools. I don't know if you or your children have used those, but I haven't. I probably should because it's math in particular. And so the question there was whether Google's undoubtedly dominant position, if I may say so, in search, general search, might have been strengthened as a result of acquiring this target company, which the Commission described actually as vertically related, sort of downstream. I know we're running out of time, but I've got 5 limiting principles. Nobody has the answer, but 5 what I would describe as limiting principles, so sort of a screen or a test to see whether this is the sort of case that agencies should be prioritizing for a phase 2 investigation or if you like, worse. And they're sort of taken sort of a combined out of these 2 cases. Number 1, when is a case problematic is the question. The target's activities must have a high relevance to the acquirer's core market. That was assessed in Google Photomath not to be the case. The second, the target's abilities must be either unique or scarce. Again, in Google Photomath, the Commission said, actually, others are offering this, we don't really see the big point. The buyer's closest rivals offer the product or service the target is active in. Because if not, this suggests that the transaction is, and this is from the decision, is unlikely to fundamentally change the competitive landscape, which, by the way, is a quote from eBay, which is apparent from the decision they made, and the Commission, drew on and said, well, if it doesn't, then maybe there's not much of a problem. Fourth, the buyer's competitors, so think about the core market and who competes with, in this case, Amazon or maybe Google here, the buyer's competitors do not have viable counter strategies. And I think this goes to your dynamic point, actually. So counter strategies they could deploy if they were confronted with such a reverse leveraging attempt, right? And I think this is important because when we consider dynamic competition, we often think about the merging parties, rightly so, but we tend to sometimes forget about the dynamism that other operators in the market undoubtedly will also display. Otherwise, they wouldn't be very good entrepreneurs. So that also has to be taken into account. And perhaps sort of a summary articulation of these screens is, and this is again taken from 2, any assessment as to whether harm will arise must be made in light of the specific market realities. So I don't think there's room for many presumptions. Such that the analysis really distinguishes between theoretical ability to cause harm on the one hand, and whether ultimately this is likely. So I thought it was really helpful that the Commission drew this distinction over many pages. I just tried to give you sort of a flavor of this. But in a sense, I think I have to congratulate the Commission for sort of deciding these cases in a way that gives us some guidance also for future cases. And I think for now I'll leave it at that because I think I'm probably over time.
Okay, thank you, Nelson. And now moving to Daniela Sellinger. Daniela, she's a private practitioner. She's a partner at the law firm Linklaters in Düsseldorf. Also, she's a law professor, and she has more than 20 years of experience in EU and German competition law. So, Daniela, could you comment on the recent trends and challenges in digital mergers?
So, thanks a lot for having me, and thanks, Andreas, for the invitation. I wanted to quickly start out with maybe challenging what had been said over the last 2 days here. So, essentially, I believe that there is no real, let me call it, killer acquisition gap. The killer acquisition gap has meanwhile been closed, and we have been speaking about a number of cases so far, and over the last 2 years in particular, where all over the globe, various competition authorities have dealt with mergers in the digital field and have either prohibited the merger, or the mergers have been abandoned, or they have dealt with the mergers in different ways, but with specific remedies. And these remedies have been very much granular, or growing into more granular remedies over the last couple of years. So if one looks at, first in terms of process, which cases can the competition authorities globally take on? Meanwhile, I would say they have more or less a catch-it-all, because they have been working with Article 22, the DMA obviously also puts down an obligation for the big tech companies to notify their respective mergers. In Germany, we have the competition tool, which allows, after a sector inquiry, that bigger tech companies have to notify their mergers for approximately 3 times 3 years, so 9 years altogether if it is extended. And that means that essentially the competition authorities can look at more or less the whole landscape when it comes to digital mergers. And they have done so, and to my mind, they have been doing that in a super innovative and very quick manner. So they have been evolving theories of harm on all levels. In particular, the European Commission has come up with new theories of harm in the latest digital merger cases. And whilst they might not always be totally in line with the theories of harms of the CMA, at least all of these are to some extent new, surprising, and super viable. So I believe if you look at that, then you can also realize there, and also in relation to German and other local authorities, that there is no need also on substance to extend and to become more bold when it goes to really enforcing the digital merger regime in a stricter sense or in a stricter way. Some of the cases, or all of these, have already been mentioned. So Google, Fitbit, Meta Customer, obviously, Microsoft, Activision, Blizzard. And if you look at the trend, and then having heard over the last 2 days that we should become much bolder, I wonder whether that is really the right approach. Obviously, one shouldn't be a softie, but I was actually thinking that something like a boftie could be good. And I was actually looking that up in Wikipedia yesterday. A boftie is something which is in between and is really good. So that could be maybe the right approach now that we have already, well, I would never say anyone was soft in the past, but I think now one has already, we all have become much bolder in the approach. And then if there is not such a big gap, then really we should be cautious in what we are doing and what solutions we are designing going forward. We have heard that also over the last couple of days. A lot of investment depends really on smaller companies in the digital area and in the digital world being able to exit the markets. Otherwise, they don't find investors. So we have heard, when I was sitting on the Competition Commission 4.0, the Association of Startups, and their representative was there and was holding a great plaidoyer on that he thought startups should be bought. And at least, there should no one interfere with them being able to be bought. And yesterday, listening to Johannes Reck from Get Your Own Guide, I thought I was really interested, because the first sentence he was saying here was that he was the CEO of the globally leading platform for travel guides. And again, I checked it on Wikipedia yesterday. He has been buying, in 2013, the local, smaller local guide platform, so to speak, called Giphy. Or, no? Maybe Gitzi, sorry. And
otherwise he would have prohibited it.
Yes. And if you read the Berliner Morgenpost, you can see that when they wrote an article on it, that all employees of Gitzi were really happy to join Your Own Guide. And maybe nowadays I would think that maybe that would be notifiable to the FCO, at least, and that also one would need to have looked at this and these two digital platforms merging. And I think now in 2024, we are much further than we were in 2013. And I think somewhere in the world, this would have been picked up likely. Last, 2 small words on the new regulation on market definition, because I think that's something which is really great. It just came out in February. We have been waiting for 25 years. I have to say, maybe I have not been waiting so much for it because I was a little bit nostalgic. It was the last thing I really had in hard copy on my desk. So now that has changed, apart from some things which are kindly printed. Nowadays, everything is more digital, and in fact, this market definition notice adapts to the new case law. And I think it is really very granular. It summarizes the last 25 years of all case law super well. And what you can see in the notice is essentially more and quicker striving markets. You see more definitions or fresh guidance on dynamic competition, in particular also relating to the UK. And distinct attributes of digital markets are really well explained. In particular, that you assess mergers on a quality basis, including environmental concerns, including data protection, and all of these can play a role and play a particular role also in the digital merger field. So I believe that that is something which is very valuable in helping us assessing digital mergers going forward, and it will also ideally align the approach, which will be great for companies on a global basis, because the companies are global players. And the European Commission has been asking all national authorities to feed in their comments into the new notice. So I believe that will be something which will create a more level playing field when it comes to defining digital markets on a global basis.
Okay, thank you, Daniela. In this first round, we got a good snapshot of the challenges we are facing in merger control, and specifically in merger control in digital markets. So we'll now move to a second round of questions, where we will try to explore in more detail what agency, legislators, and stakeholders are doing, and what can still be done in order to address these challenges. So, Tommaso, now starting with you. Given the current context, what are the options to address the challenges we heard on the first round of questions? Should we change the laws? Because we are aware that in Germany, in Austria, the transaction value threshold was introduced. And what can enforcers do with the current legal framework? We are aware of Article 14 of the DMA, Article 22 of the merger regulations. So what's your thoughts on this, on the future?
So let me start. So I think there is much more common ground than it sounds. So I think, absolutely right, limiting principle, legal certainty, super important, right? So due diligence, super important. So I think that and it's true, enforcement has fundamentally changed in the last, 1 year. But it changed because we had 5-year discussions. So it seems really another age, so 4 years ago, when we wrote that report. It was a different world, right? Now we have enforcement, we have new theories of harm, we have a lot of new legislation. We have a DMA, we have the new notice. Completely agree with you, fantastic. New piece of legislation. In the US, we have the new merger guidelines. We heard from Fiona yesterday. It's an evolution. That is a small revolution, but it's an evolution. It's just learning over the last 20 years. We have in Germany the 19A. There is this new tools for the Bundeskartellamt after the sector inquiry. So there is a lot. So, and I don't remember again who said it yesterday. So now we have to enforce, and I think that is the priority. I think it's coming. So in that sense, that is the light of optimism that I have. So I see these things enforced. So I think that is the priority. Sure, even the law has to be adapted, and so. The Monopolies Commission has a couple of suggestions. For instance, I find perfectly fine that the Commission use these referrals under Article 22 for notifiable mergers. It's a bit more problematic if it is for non-notifiable mergers. So it's we think that it was great in Germany to introduce this transaction value. I still think that for legal certainty it would be better if also the Commission would have something like that in the notification criteria. Benoit mentioned the tower case judgment and the use of 102, essentially ex post. One thing that one should think about, I mean, we don't know whether 102 has been really used rightly, but I mean, why not ask the Commission to do that too? Why only National Competition Authority? Maybe the Commission could use also 102 ex post. I mean, I still think for legal certainty, and a well-defined ex-ante merger regulation regime is better. For the firms, it's better to know what are the rules and then to go over due process, and if the competition authority says it's okay, to intervene ex post is a bit of a problem, unless you see that, I mean, there are some problems, as we have seen in digital markets. And maybe just so small changes in the rule, changes in the enforcement. I think we made steps there, the new theories of harm, so ecosystem theories of harm, data-driven theories of harm. Be more bold is sometimes to risk a bit more. I think National Competition Authority risks more than the Commission. The Commission sometimes is very conservative. IKK Schweiz have mentioned in for 102, I think also in merger control. I had a quote of the former chief economist at DG Comp to Google Fitbit. I said, yeah, you know, I mean, yeah, maybe we could have tried something else, but at the end we would have lost the case. And I think sometimes you might want to lose a case if it's a borderline case, right? So in that sense, be more bold. So use all the tools that you have, try new theories of harm, and be a bit more open about uncertainty. That is a big issue as an economist, right? So is the standard of proof? I don't know. I mean, when you are looking in the how you call it, the crystal ball, yeah, the future is uncertain. So you should value evidence differently. As an economist, I think we should move more and more into a world where incentives can be seen as evidence. If finding evidence is difficult, I know that. Lawyers and courts probably don't agree. I don't, but as an economist, I think it's useful, and one should use all the power. So when I was discussing the Facebook, Instagram, preparing a presentation, and we had all the evidence that we got and that the CMA got, and then I found some of the evidence that was brought in front of the Senate and the US Senate. So these emails of, I said, so. I mean, if you have these emails, right, so there is no way that you would allow this merger. If the Zuckerberg says, so we should kill these competitors before it's too late, and then 10 minutes later, I don't know, I didn't mean to say that, right? So to get access to these kind of documents is important, and then maybe, and that is the bridge to your session. So if you have this huge amount of information, of data, of documents, then use AI to go through it, to help to structure these kinds of information. So that is, I think, the new challenge. And I went over the 4 minutes.
No, it was great, Thomas. In enforcement, in public enforcement, we do need AI, and we do need AI in merger control. So I fully agree with you. So at the end, I do think we are facing a new dynamic approach in merger control. That's the slogan that we have. Now, moving to Marcus, could you explain, face off what we saw, or the new series of harm, and all these new contexts in merger control? What could be the potential new criteria and considerations to take into account in merger control? We think about the analysis of innovation, the motive for the acquisition, the legal nature of the acquiring company. What's your thought on this?
So Clearly, I'm the pessimist here, the Christina Kafara of the panel. Why am I pessimistic? I'm pessimistic because these questions are fundamentally speculative. And that, I think, is the problem that we need to embrace. Why are they speculative? Well, I'll answer it this way. If they weren't speculative, or if my crystal ball worked, well, I wouldn't be here. I'd be buying my 500-foot yacht alongside my best pal, Jeff Bezos, but I'm not. And that's because these things are entrepreneurial in a big way, and we are going to have to accept that digital markets, tech markets, are fluid, dynamic, really very fast moving. So how do we cope with that? Now, first point, we can't simply prohibit all mergers that we just don't like. I know no one's saying that, but it's very important that we recognize that many innovative startups actually want to be acquired by one of the behemoths, and they go into business with that objective in mind. They are actually setting up with a view to being bought out. Now, that is fundamentally pro-competitive. We want these small minnows to have ideas and then to monetize them by being bought. So we don't want these transactions killed if they are pro-competitive. So how do we square the circle of knowing that there are bad mergers out there, but not knowing which ones they are? And it does seem to me that we need to think outside the box and abandon our traditional thoughts. And so I've got two ideas in that regard. First of all, we talked yesterday a great deal about AI, and I strongly suspect that our digital tech markets, the new products that are being offered, will be, to a much greater extent than now, and now, of course, AI is already being used, but to a much greater extent than now, be AI-based. Why don't we think about stipulating as a condition of a merger that the AI itself have embedded within it some kind of competition rules so that they themselves, when they are selling their services across the internet or whatever it is, that they are themselves complying with basic competition norms. In other words, we embed competition into the AI. Now that, it seems to me, is something we ought to be thinking about very carefully. The second thing is, what about the nature of the legal personality of the acquirer? One of the big problems of big is beautiful is that if you have a powerful, a dominant undertaking in a market, shareholder value, or the imperative to deliver shareholder value, becomes uncontrolled by competition. And shareholders get more and consumers pay more. That is why competition law focuses on competition. It matters to control the entity, the corporation, that is shareholder value driven. So why don't we think about corporations that are acquiring, which are not shareholder based? What about the sort of public service corporation that exists in the US, where you distance the shareholder value and you have an obligation to act to a greater or less extent in defined public interest circumstances? And one says, yes, you can pay out of the company to shareholders to a limited extent, but that is hugely controlled by a reference to public interest criteria. So what I'm saying is we should think outside the box. We should not bet on being able to predict the future, because I don't think we can. We therefore, if we want to retain an ex-ante regime, which clearly we do, we need to be thinking about other ways of working out how to control the adverse effects of mergers that may be, but which we do not know, are adverse to the interests of society as a whole.
Okay, thank you, Marcus. Now moving to Nelson. The former panel talked about Article 102 and the role of DMA in order to address some of the challenges that in the past we have concerning the application of Article 102. But when it comes to the DMA rules on merger control, what's your thoughts on this? What's the possible impact that Article 14 and the obligation of the gatekeepers to communicate any transaction in the digital sector will have in the future, namely when related to the application of Article 22 of the merger regulations? So what's your thoughts on this?
Sure, and thank you. I'll try to be succinct. the first point might be around the interplay between Article 14 DMA and 22 EUMR. I think potentially there could be a wider expectation out there that this is somehow a game changer. I've certainly heard it in some conferences, and my first hypothesis is that this will not be the case. The game changer, I think, was Article 22 and its reinterpretation. That I think, changed quite a lot in the way in which these transactions are approached. Article 14, really, all it does is an obligation to notify, right, provide information. And I really doubt that there would have been all these dozens of transactions that the Commission or others just had no idea or no knowledge of, that wouldn't have been complained about, that just proceeded without any scrutiny. So I think that's point one. I don't think we're going to see a big step change in any event, and people may disagree with that. Point two is, perhaps counterintuitively and a little bit provocatively, I suspect that there will be arguments that the DMA will actually result in more mergers either being cleared or providing a path for more limited remedies. And here's why I say this. I've been thinking about this a little bit also in the context of my previous role, where we've often been sort of confronted with arguments to the effect that, well, you know, your theory of harm doesn't hold, because for me to be engaging that sort of conduct, that would be an abuse of a dominant position, and that's illegal, and I would never engage in illegal activity, so therefore I wouldn't do it, your theory of harm fails. I have to admit, I gave those arguments often more short thrift. I didn't really, but you know, when you look at what the European courts have said about this in Tetra Laval, I just want to read this out. This was a general court. They said, although it cannot be presumed that community law will not be complied with by the parties to a conglomerate-type merger transaction, such a possibility cannot be excluded by the Commission. So we cannot exclude that. That's good. While it is appropriate to take into account in its assessment incentives, which you just said should be evidence, incentives to engage in anti-competitive practices, the Commission must also consider the extent to which those incentives would be reduced or even eliminated owing to the illegality of the conduct in question, the likelihood of its detection, action taken by the competent authorities, financial penalties imposed, and so on. And this is just in the context, this is basically the interplay between merger control ex ante and 102 ex post. So it had to be taken into account. Those incentives, you know, were relevant to the overall assessment. Again, I'm not saying that that's a particularly very powerful argument. But now we're moving into a new world, because now we've got ex ante regulation, so we've got ex ante and ex ante. And so obviously there's been lots of sectoral regulation, for instance, that you know, the Commission and other agencies had to grapple with in this context. And there too, you see, it reminded me of a case I did when CVC acquired Recordati many years ago. We had market shares of around 90% in some jurisdictions, and the case was nevertheless cleared owing to the Commission finding that, you know, the way in which, in that case, the pharmaceutical industry operated and regulation around it, there were incentives not to charge higher prices. And you see, I'm not going to name them all, but you see similar cases in gas and electricity. So where you had sectoral regulation, the incentives arising from that and the sort of the need to comply were taken into account in the Commission's forward-looking assessment, and perhaps rightly so. So if I'm now the Commission, and I have concerns that have been reflected in the DMA, and as we know, there's a long list of do's and don'ts, self-preferencing, and so on. If those fundamentally amount to what the theory of harm would have been, I predict that quite a few of those decisions, if there's intervention, will go to court, and I think it's going to be difficult to justify why behavior that's explicitly addressed in the DMA would then occur. Of course, lots of conditions are these designated core platform services and so on, but there may be sort of this element where agencies have to think about either developing another theory of harm that isn't captured by the DMA, which may well be true to the extent that it's outdated at some point. But I think there's an argument, and maybe this is not a bad thing. Many of us in the room think the DMA, and hope the DMA will work. Well, if it does work, and if it is effective, then those transactions, it's not clear to me why those shouldn't be proceeding.
Thank you, Nelson. Now, moving to Daniela, when you think about digital mergers, typically they have a global scale. So you have different jurisdictions being called to review those operations, and they have different types of, I would call it power, because the smaller jurisdictions won't have the same impact in the analysis that the bigger one has. So what do you think about this? Do they need to coordinate? How can we coordinate between enforcers when it comes to merger operations that have a global scale?
So thanks a lot, Nuno. And I really think that's one other really important point. the more the competition authorities coordinate globally, the better. Taking that from the company's perspective, again, for them it's key to have a process which is transparent and which is also clear on timeline, ideally, and on substance, obviously. And in older days, so to speak, when my M&A partners came into my office and said, well, do you think we can clear that merger by year end? That was approximately when the autumn leaves fell. Nowadays, it's more like I say, when the spring flowers blossom and come up, because it takes long. So seriously, if you look at the statistics for a normal kind of no-brainer merger, generally speaking, you have to look at 9 to 12 months. That's because it's not just the competition authorities looking at the merger, but nowadays you also have FDI, you have FSR regimes. So it's a super big puzzle globally with lots of various competition authorities and other authorities assessing the merger, and therefore I think cooperation is key there on the process to ideally have it as quick as possible, which the Commission and the national authorities do, and they provide clear guidance very quickly often. And I think that is something which globally could to some extent still be improved. And on substance also, obviously, it's nice and helpful for companies if they know in digital markets what to expect precisely, also in terms of market definitions. And there, whilst, as I said, I like the market definition notice, what it says is that you can always leave all markets open. And maybe that's a plea. It would be really nice if sometimes markets could be defined for the companies, because it will then enable them to have a clearer view on prospective mergers, but also on other things than if you leave it open. So in practice, and that's my last point, I totally agree with everybody who has said that it would be nice if all competition authorities had more resources so that things can be moved also even quicker. And maybe also the cooperation mechanism as it stands now, I think it's working really well, but I guess also that could in certain instances be improved on a global basis. Thanks.
Okay, thank you. Andreas, taking into account the previous panel precedent, can you give you just 5 minutes, just a final remark and final comments? Thank you. You're always very timeline in our ACA meetings. Yeah. Andreas always starts and finishes at time, so I will try to do the same here. So just for final comments, 1 minute for each one, if you want to make some any remarks that you would like. Marcus, starting with you.
Well, innovation is great. It moves quickly. We need to embrace it, and we need to be bold about it.
Oh, great. Less than 1 minute. So, Tommaso?
I think learning is fundamental in life for everybody, for firms. It's the same for antitrust authority. Learn from the past. We see it's a powerful tool. We need it desperately. And the antitrust authority have some responsibility now, because we don't want to end up in the Christina Cafara dark dystopian world. So we are in your hands.
Nelson?
Very briefly, to all the enforcers in the room, be bold, be innovative, focus on what really matters, and don't inadvertently cut off important funding for companies that are really innovative and contribute to our society overall, who are looking to exit strategies that you might inadvertently cut off.
Okay, great. I took good note of your message. Yeah. Now, Daniela?
And finally, I'm very positive when it comes to digital mergers and their future. So I think everything is looking really, really good. And be bofty. Thank you.
Okay, thank you so much. I do think you agree that it was a very interesting panel. Thank you for your thoughts. I took good note of everything that you told. These are certainly interesting times for merger control enforcement nowadays. The more dynamic approach, I would call it once again. So please join me in a round of applause for the speakers. And